Good evening, participants. We all are aware that how corruption erodes democratic governance, hinders the development of a country, and also undermines our trust in the government. Today, we are honored to have with us K.V.J. Rao, sir, who is an anti corruption activist and has been relentlessly leading and fighting against corruption in the airlines industry, be it the judiciary or real estate sector. So, we are so honored to have you with us and really looking forward to today's session. A very warm welcome to you, sir.
Thank you. Thank you very much, Malvika. And I thank this platform for giving me an opportunity to put in my experience before a lot of other people. Uh,
It's our pleasure, sir. So, before you begin, I would request you to share your journey. How did this career transition happen? You were working with Air India, then you started fighting against the public servants, the judiciary. So, sir, how did this shift happen? Or rather, why did it happen?
Malvika, I was a very happy-go-lucky man, as you would call it colloquially, till around 2010. You see, I was flying with Air India. Air India was a government organization in those days, run by the government, of the government, and the corruption was very deep rooted. But we ignored it to certain limit. Till in around 2010, we observed that a few corrupt public servants came into Air India and in collusion with DGCA were modifying rules left, right, and center without any power or any authority. I mean, they just looked at their promotion or the profit of the company. They did not look at the flight safety angle. So that's when we started exposing corruption. And then the Boeing deal also happened. We came to know of a lot of things about the Boeing deal going sour, how it went bad, how because of the Boeing deal, the whole uh, Air India went topsy turvy. I mean, it'll be a very lengthy thing if I go into that. But then I had put certain things on Facebook at that point of time. And the powers that be, that is the public servants at that point of time, did not like what I was doing. So if you Google the year 2012, there's the top 10 cases in India for being arrested under Section 66A. I and a colleague of mine belong to that. So we were arrested under 66, Section 66A of the Information and Technology Act. And I had a very good team of lawyers on the civil side, but on the criminal side, my team couldn't cope up with the corruption that was happening. So I spent, or rather, we spent 11 days in a lockup till some, like I said, there are good public servants, there are bad public servants. So we had a good judge who granted us bail, and that's how I'm before you speaking to all of you all. But let me tell you, at least 80% of the judiciary, of the public servants are, should I put it, blatantly corrupt. And I take full responsibility for my statements. I don't shy away from it. So that's how I wanted to expose. In fact, in 2013, we had filed a writ petition, Malvika, and till today it has not seen the end of light, where we had highlighted the flight safety violations that DGCA was indulging in. It did not have the powers to issue rules for us, but it was making rules left, right, and center. Till another gentleman who's an activist called Yashwant Shenoy, we filed a case in the Delhi High Court. And that's when we came to know that till 2016, DGCA did not have the powers to make rules for us. So the corruption is so deep rooted, and this corruption goes right to the top. So that has been my journey. And since then, I've been relentlessly fighting, exposing, and to be very honest with you, I have found some good lawyers, and I have found some of the senior counsels who are as corrupt, who buy over the judges, who buy orders for themselves. And I have exposed this in open court, Malvika, so I can make a statement in on this forum as well. Like the judges go by the face value of a person. Very few judges have where I've said, sir, I'll lose a case if I argue because you'll go by face value, and the judges have said, no, Mr. Rao, you argue, and we will not go by face value. And I have won certain cases at that point of time. Later on, there was a gentleman called Joseph Matthew who was working in this redevelopment area in Pantanagar area. And when I went and met those people and the condition, like, imagine 14 years, no shelter over your head. Builders are not paying the rent. They were treating you absolutely shabbily. They used to, like, throw you out. When I looked at that, and that's when I started looking into MADA and SRA schemes. And let me tell you, every MADA project that is sanctioned by the MADA is corruption personified. In fact, 2 months back, we got an order. I mean, with great difficulty, we got 46 orders to file FIRs against the vice president of MADA, the CEOs of MADA, and they are running from pillar to post, trying to obtain bail, trying to get the FIR squashed. We are working on it. The matter is in court, so I wouldn't want to discuss much about it. But that has been my journey from 30,000 feet to ground level. So that's my life today, Malavika.
So sir, generally our citizens say यही चलता है और कुछ नहीं हो सकता. So sir, we hope that by today's session we at least awaken one of our participant who can join you in this fight.
True, Malvika. I also hope, and with that hope only, I have come onto your platform. I mean, I also do a lot of seminars to educate people on how to fight their own cases. I'll be doing one in Nasik on the 25th of January. It's free. I don't charge for these seminars. I don't do anything. I only teach people how they can fight and how they should get over this chalta hai attitude. Because understand one thing, today the fire is at your neighbor's doorstep, tomorrow it will be at your doorstep. And if you're not going to help your neighbor might not help you. So you have to be prepared to fight your own battles. And that's exactly what I do. And I also have my colleague with me, Swaroop Kulkarni, who also has been fighting this battle. And how is all I can say.
Yes sir. So sir, without further ado, let's begin with the session. And participants, in case you all have any queries, we'll take it towards the end in the Q&A segment. Sir, we can start the session.
Thank you. Good afternoon, everybody. From the time a citizen is born till his death, the only inevitable person that he has to deal with is the public servant. When you are born, you have to get your birth certificate, and when you die, you have to get your death certificate. And in between, all the innumerable certificates from the income tax, from the GST. I mean, you name the departments that have been created by the government. You have to deal with a public servant, whether you like it or not. That they are part and parcel of your life. So get that very, very clear. Having said that, they being part and parcel, they are termed as public servants. But unfortunately, most of the public servants behave like they are Lord and Master. And it is really sad to see how shabbily they treat people who don't know the law or who don't know the rules. I visit a lot of offices with a lot of poor people, and I see exactly how, like, I visit the deputy registrar's office. I visit the MADA office. I visit the SRA office. I appear pro bono for a lot of people in the lower judiciary. I appear in the High Court for pro bono for some of the people that I'm fighting at this point of time. And I can see corruption at every step. And mind you, when I say every step, these are even the baby steps taken into concept. And that really riles me. I should not be recommending this, but what I give gratuitously to somebody is to be accepted, but a demand to be made is something that is not acceptable to me. And I abhor it when somebody says, nahi, nahi hoga. Like we wanted to file around 46 matters. You won't believe the judicial clerk took 6 months to file 46 matters. She said, नाही मी एक दिवसातून एक दोनच करणार, मी जास्त करणार नाही, आम्हाला वेळ नाही. So these are the people we have fought. These are the people I had to tell them, look, if you behave like this, we're going to take it up further. And I have taken it up further and I'm known to take things further. Having said that, let me start the session in the legal format that it should be. We all know of public servants. The legislature at that point of time, the reason why I said that point of time is in 1947 when the constitution was written, the code was written, the penal code was written, the criminal procedure code was written. They felt like the public servants were really public oriented. So they at that time introduced this section 197 to protect the honest, efficient, and do-gooder of the amongst the civil servants. That was the reason 197 came into being. And section 21 of the CRPC, of the IPC, defines the public servant for you. So if you want me to read it out, I can read out the sections for you, but we'll read out this one section and then I'll go ahead. The words public servant denotes a person falling under any of the description hereinafter following, namely, every commissioned officer in the military, naval, air force, every judge, including any person empowered by law to discharge, whether by himself or as a member of any body or person, and any adjudicatory functions. Fourth, every officer of a court of justice, receiver, commissioner, etc., every juryman, every arbitrator or other person, every person who holds an office by virtue of which is empowered to place or keep any person in confinement, that is basically the police, and every officer of the government whose duty it is such to prevent offences, to give information of offences, to bring offenders to justice, or to protect protect the public health, safety, or convenience. Now, this is a broad spectrum of the definition of public servant. Now, in India, we have three types of public servants. The government employees who draw their salary directly from the government are public servants. The second category is these public servants when they are deputed to other government controlled public sector undertakings. And the third is the officer of a public sector undertaking, or the act defines. Like the Companies Act defines some of the officers of those companies as public servants. The MCS Act defines the committee members as public servants. But just because they are called public servants, are they protected? Is what we will be discussing today. Now, if we read section 197, section 197 was created with the sole intention to protect the public servant. And section 197 of the CrPC reads that when any person who is or was a judge or a magistrate or a public servant not removable from his office save by or with the sanction of the government is accused of any offense, that's the first category. In the case of a person who is employed, or the case may be was at that time of commission of the alleged offense employed, the second category. In case the person who is employed, or as the case may be at the time of commission alleged offense in connection with the affairs of the state government also. So central government and state government come into play here. Now, what exactly is 197? It says, no court shall take cognizance of any offense alleged to have been committed by any member while acting or purporting to act in discharge of his official duty except with the previous sanction of the government. Now, this is where the, what should I say? This is a chain, like the public servant from the bottom to the top. Now, when we say public servant, even members of the legislature are public servants, defined as public servants. We have the IAS officers who are defined as public servants. We have the IAS officers who come on deputation to public servants, to public sector undertakings as public servants. And then we have the public servants of the state by itself. So Section 197 was created to protect these people when they done their work judiciously and as mandated by the law. But unfortunately, today 197 or the need for sanction has become like a tool that is used by public servants to protect themselves. Like I said in the beginning, today most public servants, and I don't put them any of the class outside it. You can take whether it's a government servant, whether it is a IPS officer, an IAS officer, an IFS officer, whether it is the judiciary, whether it is a quasi judicial officer. Today, they all you go to their office, they treat you as as though you are an impediment to their business, whereas they are there to actually serve you, and they behave like lord and master. But when these very people are caught in corruption, the first cry is, I am a public servant protected by 197. And that is the plea every public servant has taken when an action is being sought against them. Now, since we are now discussing how the corruption seeps in, like I will start with my own journey. Like I said, the when the flying crew fly an aircraft, we have something called flight duty time limitations. This has been already decided by a tribunal, the Central Government Industrial Tribunal. So that followed. Air India was the only airline at that point of time. Later on, the low cost carriers came in, and the low cost carriers came in and they were cutting corners. And when I say cutting corners, they were cutting corners by virtue of the staff required to be on board. Now, in the DGCA, the DGCA only defines a minimum crew. It doesn't define a maximum crew, and it defines the flight duty time limitations. So that is, flight duty time is the time that a cabin crew or a pilot or any of the crew on board the aircraft can perform their duties. So the hours are specified as to, like, if let us say if it was a regular flight, the maximum flying time would be 10 hours and there would be 4 hours of ground time, so that was 14 hours. So when Air India brought in these long range aircrafts, they had to sign an agreement, a tripartite agreement between the cabin crew union, the Air India, the government, and the DGCA. So this was signed. It was already decided that the maximum flying time will be 20 hours with 5 hours of horizontal rest and all. But the reason why I'm saying this is later on we came to know that without the sanction of the government, these DGCA officers, they done it either for gratuities in kind or cash. And I'm making this statement very bluntly. Because we have got documents. So let me be very candid about it. So we said that you don't have powers to alter these rules, but they said nothing doing. We will do what we want to do. And the biggest weapon these public servants, or I would say the corrupt and the criminal minded public servants had, was suspend the employee. The moment you suspend an employee, it affects his earning. So the rest fall into place. So they will set somebody as an example. So I was one of the examples that Air India sought to set out. When I exposed the corruption, when I exposed the flight safety violations, and I said, like when we filed a writ petition in the Bombay High Court in 2013 and another one in 2014. In 2019, the Honorable Bombay High Court told me that no, it is your responsibility to report violations. You cannot, otherwise you are liable. And I done this in 2013. And in 2014, they terminated my services saying you wrote a letter to DGCA that there are violations in Air India. But then both were the same. Government of India and DGCA are government itself. So they were judge, jury, and executioner. And like because that happened, then we took this matter to the criminal courts. Because these were flight safety violations and they invoked section 336 of the IPC, that is endangering life. So when we started filing criminal cases, we found that even the judicial officers were helping them out. Like I had to fight many a battle. I had to fight many a battle in the judiciary, because first thing is, if you want to take a matter to court, you can't go directly to the high court. You have to take it to the trial court. Before going to the trial court, you have to go to the police. And honestly speaking, the police are the biggest corrupt bunch of people. You will not be able to get an FIR registered in any police station without a bribe. And they will give you 150 excuses galore. So when you can't get that done, then the next legal step is to go to the area DCP to tell him that the police have not filed. You might think that the DCP is something better. Let me tell you, the DCP is worse. The DCP acts like a postman. He sends that letter back, the complaint back to the police station. And despite High Court judgments, despite Supreme Court judgments, the police will not file an FIR. And when you take it to the trial court, the judge will make, the judicial officer will make you run around. And he thinks like he's doing you a favor by passing an order, a legal order. We are not asking for anything extra constitutional. We are not asking for anything. So that is how my journey has started. It started with how the police did not do their job. We went to courts. We had good judicial officers who gave good orders. And then I started finding the officers, they give you excuses galore. And they think that you don't know the law, especially when they see a person who doesn't have a black coat, they think like he doesn't know the law. I do concede. Some of us, like, rashly get into court saying, I'll argue my case, but it is not so. It is not that easy. You need to know your fundamentals. You need to know the law. You need to know the act. You need to know the interpretations. You need to know the judgments that support your act. So I started presenting myself as party in person in the high court, in the trial court, and I found that every magistrate would look for, Acha, is that so? No, we will give them a chance. By giving it is basically the courts, by giving a long rope to the police, have hung the citizens, because the police know that the courts will not take action against that. You go to any court and say you want an order against a public servant, and that court will give you 550 excuses, saying, no, public servant is involved, there's an amendment to the act. They got this amendment to the act. The amendment to the act came on 30th August 2016. It only read that no magistrate under 156(3) can pass an order against a public servant without sanction, prosecution sanction, if he felt, now this is the catchword, if the magistrate felt that the act was within his jurisdiction of the public servant. It was only then we had to get sanction. But every magistrate, the moment they see public servant, they will deter you. No, sanction has to be brought. And I have seen many corrupt judges in this. I can name them, but I don't want to name them personally. But I have had this experience in the 65th court of Andheri. I have had this experience in the 66th court of Andheri. In the 66th court in Andheri, the magistrate made a false statement in his own order. And he says you can do what you want. I have filed complaints right up to the Chief Justice of India, but that magistrate is still sitting there. So imagine where the corruption goes when it involves public servants. And this was a fraud of Provident Fund of 300 crores. If you open the criminal manual itself says somebody has looted your Provident Fund, it is a cognizable offense, FIR has to be registered. And this magistrate of the 66th court passes an order that they are protected by the act, whereas the manual says they are not protected by the act. So then what do you do? So we have filed complaints. So that now when we found magistrates, like, you go to any court for a 156(3) order, without a blink, the magistrate will convert it into a 202 application or a 200 application. For them, it is like, you take a 156 3 application to any trial court, it is like you're carrying the COVID vaccine with you. Nobody wants to touch it with a bajpur. And they will give you excuses galore in not wanting to file the pass an order. And let me tell you, the Honorable Supreme Court in 1995 held that to file an FIR against a public servant, there is no need of sanction. That is why I read 197 to you. What does it read? Section 2 of 197 reads, no court shall take cognizance of any offense alleged to have been committed. So, cognizance. Under 156.3, the judicial officer is not taking cognizance. He only on the plain reading of the complaint has to decide whether cognizable offenses are revealed or no. And Lalita Kumari's judgment has made it very clear that even assuming for a moment that it is a false complaint, the police has to file the FIR. And after investigation, if it is found that the complaint is false, you can file an FIR against the person filing the false complaint. But they don't want to follow it. If you can get a 156.3 order from any court very easily, let me tell you, you are the luckiest person on earth. I have seen where magistrates have forged prayers and not granted 156.3. I have seen magistrates telling us that, how does my jurisdiction come in? Haven't they heard of the zero FIR? I mean, the Sushant Singh murder case was the biggest case, the largest case where the Supreme Court held that an FIR can be filed at any police station. But still the police will not do it and the magistrate will not direct the police to do it. In the 66 court in Andheri, I have got a matter where in 2021 I filed a complaint against a fraud. There is a gentleman who has looted government of 3 crore rupees accepted by the government. The police did not do anything. When I went for a 156.3 order, 3 magistrates changed. We are in 25 today. Till today, I don't have a 156.3 order. The order passed in the 66 court said that I want to ask the police what they did. And what did the police do? The moment I gave that order to the police station, they called me to record my statement. But was that the order of the court? The court said, what did you do prior to this 156.3 application? And the magistrate has the temerity to tell me, Mr. Rao, they're calling you now, go. Maybe they will file. Maybe? How dare he say that, maybe the police will file? It is the duty of the police to file it, especially when a government servant is saying that, somebody has defrauded of 3 crores, 300 crores. Imagine in Parliament a statement was made that employees 300 crores was diverted, despite which the 66 court says no, they are protected. And he dismissed my application, not 1, not 2, not 3, 21 applications. And I've got 21 more pending, and he's refusing to hear them, saying that, you told me I'm helping the accused. I said, but that is what you have done. So he says, no, I don't want to hear your case. Look at the temerity of the judicial officer. The judgment, the constitution bench of the judgment says when there is criminal breach of trust, Superintendent Rembrancer versus S.K. Roy is a judgment. It says if something has been entrusted to a public servant and it has been defrauded, there is no need of sanction. Mata Jog Dobe is the fundamental judgment which no judicial officer knows. Or if they know, they pretend they don't know. In fact, when a magistrate converts a 156.3 application, CrPC application into one of 200, it is an illegality. Even though the section says he may pass an order, the may in that clause is a judicial application of mind, not a whimsical and fanciful mind of the judge. As Justice Cardozo said, the judge is not an errant knight to do as he pleases. And that is exactly what happens in the lower courts today, including the high courts. This is my court. I have done it. Do what you want. This is the temerity with which most judicial officers talk to you today. And I'm sorry to say this, and I'm making this statement with full responsibility. There are senior counsels who buy judges. There are senior counsel who buy orders. And I'm going to be naming, I'm filing a perjury application against all these people. It is sad. It is sad. Today, the third arm of the government is letting down the people. And every magistrate will wait till his transfer. And then he says, okay, I'll pass the order knowing that he's going to be transferred. And once he's transferred, the litigant has to go back to square one, argue the matter all over again, convince the judge, convince the judicial officer. The judiciary, I'm sorry to say this, has become a mockery. Today, no common man can think of going into any court because justice will not be done to him. And I'm a living example. And these public servants and these police officers and these judicial officers, they know that the poor man will not go to the higher court because it costs money. How many people will do pro bono work? I have a judge who's passed an order where the Supreme Court has said that stopping of the salary or altering the salary conditions is a criminal offense, and the judge says no, it's not a criminal offense. Is the judiciary is bound by Article 141 of the Constitution of India, which says that any order passed by a higher court has to be followed by the lower courts, all the lower courts and the subordinate judiciary. The latest judgment also, authored by Justice Gawai, it says even though the High Court is not subordinate to the Supreme Court, they still are bound by the orders passed by the Supreme Court. And they said that if we allow a trial court to interfere with our judgment, there will be no rule of law. Because then every judge will be writing his own law and his own orders, as done in the 66th court, as done in the 22nd court in Andheri, as being done in the 66th court in Andheri, 65th court in Andheri. These are documented. And let me tell you, I have addressed mails to the Chief Justice of India, to the Chief Justice of Bombay High Court, but nothing has happened with documentary evidence. So this protection of 197 is very erroneous. When the IAS officer is deputed to a public sector undertaking, he loses his protection under 197. Like I in the beginning I told you, there are government servants who draw their salary directly from the government. So the judiciary comes into that. Then there are public servants who draw their salary when they're deputed to public sector undertakings. There is a judgment called Mohammad Haji Raja which clearly says that the IAS officers, when they come to on deputation to a public sector, lose that protection. But I have got at least 10 orders by judges and falsely misled by senior counsel saying, sir, they are protected by 197. Interim relief granted. 6 years that case has not seen the light of day. After taking interim relief, these people run away. We thought the Asian road reload surfacing judgment came as a breath of fresh air. That also some lawyers went and challenged because they have to. It is their bread and butter. The more the interim relief is delayed, the more the client will pay him. But what suffers is justice suffers. And people are paying a heavy price. Today, people, you tell them you have to go to court, they say, sir, jane do na. As Malvika said in the beginning, chalta hai attitude. It is not chalta hai attitude. It is the frustration of the man ki मी कुठे जाऊ कुठे मला न्याय मिळणार. As they say in Marathi, I'm sorry, pardon me, की शाण्या माणसाने कोर्टाची पायरी चढू नये. But I have taken that further. एकदा चढलं की मागे वळून बघू नये. You take it ahead. Take it to its logical end. I have caught judges in the High Court lying, and I said, no, I will not leave your court till you write in the order that you made a mistake. And they had to. And the biggest threat that a judicial officer holds against the public is contempt of court. And I thank Mr. Bharadwaj, the then law minister, because earlier even truth was not a defense in contempt. But thanks to him, it was amended that truth is now a defense under contempt. And the judicial officers use that robe as a shield to indulge in corrupt practices. The public servants use their designations. You go into MADA office today, every file is a cesspool of corruption. Every file. The builders have taken over the MADA SRA. The builders have taken over the courts, the lower courts. The moment you go against a redevelopment project to any lower court, rest assured it will not be heard. Tariq pe Tariq. Whereas there are two High Court judgments, Suggestion Transport from the Madras High Court, which says that a 156.3 application should be heard within 15 days. Same thing was held in Santosh Kumari versus State of Uttar Pradesh. But if you can get an order in 15 months, I am telling you, you will be the luckiest person on earth. And it is not as though a 156.3 application needs rocket science. Read section 144 of the 154 of the CrPC. What it says, a complaint in writing has to reveal cognizable offense, FIR is maintainable. Lalita Kumari said it, Sadakshri said it, latest judgment, Sadakshri, State of Karnataka versus State of Karnataka, Supreme Court. I can give you judgments galore, but none of the lower judiciary will follow it. In fact, Sadakshri went one step, XYZ versus State of Madhya Pradesh went one step further and said just because a litigant has certain evidences with him, converting a 156.3 into 200 application will be travesty of justice. Because like I said, the word may is a judicial application of mind and not a whimsical and fanciful application of mind of the judicial officer. Like I'll give you a simple example. 10 days back, I was in the court. From 2019, this is an incident that took place in 2016, FIR is filed. From 2019 till last month, the accused never comes to court and charges are to be framed. So I intervened and I said, sir, the accused is not present for so many days. What is happening? Charges are to be framed. The magistrate was kind enough. He issued a bailable warrant against the accused. And somebody from the court called up the builder and said there's a bailable warrant issued against you. Believe it or not, in half an hour, the builder was in the court with a lawyer, got that bailable warrant cancelled and assured that he'll be present. So see the corruption, the court officers. You go to any court, the interpreter behaves like he's Chitragupt. I will decide when your case will be heard, not the magistrate. And the common refrain from judicial officers are, my board is very heavy. And I have to tell them, sir, the board is heavy because you don't do your job. If a 156.3 application is heard within, I know 15 days it's impossible, but if it's heard within 90 days, I assure you and the judiciary that 30% of the cases will disappear from the face of the trial court. But the magistrates don't want to take action against the police for not filing the FIR. In the redevelopment matter, it is thanks to some good judge in the Bombay High Court who said no, if a builder cheats the members, it is a criminal offense. But even today, you go to any police station and say the builder has not paid me my rent for the last 14 years, file an FIR. You will get a handwritten, a written letter from the police station. Hey, Diwani ahe, तुम्ही कोर्टात जा. If the courts are going to do everything, why have the other public servants? Why have the police? Like I was in the sessions court for somebody's anticipatory bail. The police is saying we didn't file the FIR despite a court order because the election process is on. So if the election process is on, during the election process, let's close down the police station. No, they can't file FIR. So thieves, robbers, everybody can loot and go. Is that a logical explanation? Another thing is VIP visit to my area. So if the VIP visits, then the police will leave the police station, run behind the VIP. The system from the top to the bottom is convoluted. Everybody is trying to make a fast buck. Like builder, a poor man goes and he says, the builder has cheated me, the police won't file an FIR. But if a rich man goes and says that and he's got influence, FIR is filed immediately. You read it every day in the papers. Suddenly, police have filed FIR against builder. How? How are you not filing for the poor people from Pantanagar? How are you not filing for the poor people from Kanambar Nagar? Same, identical crimes. Builder has cheated me. But if you're rich, your FIR gets filed. If you're poor, you get thrown out onto the street. Forget getting thrown out onto the street, it's okay. You are abused with the vilest of language. I am now dealing with one case in Pantnagar police station. Can you imagine the police have filed a C summary? We went and filed a protest petition. We told them, sir, these are 2 pages. Both are government documents. Both have been submitted to government organization. In one, 2 lines are blank. In the other two, it is filled up. So it is a forgery. The police officer saying, हाँ ठीक है ना, क्या हो गया इसमें? So I had to tell the police inspector, अगर आपको फोर्जरी का मतलब मालूम नहीं ना, आप वापस जाइए पुलिस एकेडमी. I said, आप लोग को कोई कुछ करता नहीं, कोई कुछ कर नहीं सकता करके आप ये कर रहे हो. Because how many people will fight against the police? The police are vindictive. They are cussed. And this is from the bottom to the top. It's not a one-off incident. An FIR of a common man getting filed is the eighth wonder of this world, at least in India. So many women are molested, raped. The police, they don't even bother to file an FIR. Till it goes into the media, it becomes big, then they will file an FIR, and invariably all the wrong sections will be put in because the money has paid them the money, the police the money. And when I'm saying something today, like we can prosecute all these people, there is no protection granted to anybody. Because if you say that I'm a public servant and I'm protected to commit a crime, and I can't be prosecuted, then the constitution has no meaning. I have had so many people, I have had so many incidents, and now I will give you judgments of, how the Honorable Supreme Court in a judgment called R.R. Parekh versus State said if a judicial officer has not followed the law and has not followed Article 41, kindly read corruption into it. There are so many judgments that are coming out now against judicial officers. Prabha Goyal is another case. I can give you judgments galore because the amount of research we have done, I and my team. I mean, I'm proud to say I teach law students also. I have them as interns. I teach them every day. And the amount of research, the amount of debate, the amount of discussion that goes on before we even open our mouths before the courts. There is, like, when I go to court, magistrates are upset. They say, why should we permit you to argue? Why not? There is provision in the law. And unfortunately, and this is with due respect to the few honest senior counsels, most senior counsels only teach their juniors how to fabricate things, how to mislead, even though it goes against the judgment of the Supreme Court, which says that the advocate, the lawyer, the senior counsel, whoever it is an officer of the court, and he has to produce the truth before the court because the courts take decisions based on those statements made by these people. But unfortunately today, because of face value, money value, nothing. 141 has no meaning. Twice a senior counsel has obtained interim relief by fraud in the High Court. And I went to the court also and I said, how did you grant it behind my back? He says, under the inherent powers, I can do anything. This is the statement made to me by a judge. And I said, sir, that is a fallacy you're living in. Even under inherent powers, only to be rarely used. 482, an interim relief is to be rarely used. Today you go to any court, High Court, interim relief stay against filing of FIR is granted like they're distributing chocolates on Republic Day or Independence Day. When there are question of facts involved and the Supreme Court has categorically said that you cannot stay the FIR. Kurukshetra University versus State of Haryana, Habib Jilani versus State of Telangana, where Kurukshetra University judgment is repeated, saying how does the High Court even think they have the powers to stop filing of an FIR? Because if you stop the FIR, the investigation stops. So if what now is happening is under 482, the High Court is conducting trials. The High Court is recording evidentiary value, which is illegal, which is not permitted in law. After the FIR is registered and after statements are recorded, maybe the courts can interfere. And of course, the Bhajan Lal's judgment versus State of Haryana, those 6 parameters, I concede those if it falls within the 6 parameters, 482 is there, 226 is there, 227 is there. But when there are facts to be decided, can the High Court go into decision of facts? No. Either under Article 226 or Article 227 or under 482 of the CrPC, the court cannot go into recording facts. That has to be left to the trial court. Even 120B against a public servant, the Supreme Court has held P.K. Tiruvani versus Union of India. Read the judgment. It says once 120B is put, let him go to trial and say that he is not part of the criminal conspiracy. But all these judgments have no meaning today. Article 141 has absolutely no meaning. Today, courts are absolutely legislating. Today, it is legislating by courts, where the court decides what needs to be done, which is prohibited in law. If you read the Muhammad Haji Raja judgment, it clearly states that if any court tries to bring an employee of a public service sector undertaking under section 197, it will amount to legislation by court, which is not permissible. But I had 2 benches of the Bombay High Court that overlooked that judgment and granted interim relief to the criminal minded people from Air India itself. Even under Article 142, which gives wide powers to the Supreme Court, Honorable Supreme Court, even there the Supreme Court says the statutory provisions of the law cannot be tampered with. He says we only interpret the law, we do not make the law. The courts only interpret and do not make the law. Today as a litigant, I personally have filed around 200 cases on public servants. And I'm fighting them tooth and nail. The moment you go to court, they see you. No, Mr. Rao, today we can't hear your arguments. We are very busy. I've got 3 judgments, I've got 4 orders. And the latest excuse given to me by court is, my steno is absent today, Mr. Rao. This is the 3rd time yesterday in one of the courts, the judges told me my steno is absent today. So I can't dictate the order. The judiciary has really let us down, has let the common citizen down. And the common man is suffering. Like take me, I've been terminated on a non-existing document. And I have got law firms who have fleeced Air India in crores of rupees to defend that. I have a High Court order from the state of Telangana saying that these rules that Air India is following do not apply to their workmen. They have been repealed in 2013. But me and my colleagues, our services have been terminated in 2014 under a non-existing service conditions. And it is being defended by the top law firms in India. When I say top, they are the topmost, the creamiest. And I can name them also. I've got no hesitation. I have faced a defamation case in the Delhi High Court where they lost. Non-bailable warrants were issued against me. There are some law firms who create litigation so that their purses and their bank balances thrive. And most judicial officers play their tune. There are so many judgments which clearly says that if the public servant is questioned as to why did you do this act, if he cannot substantiate it on the basis of law, it is corruption personified. No protection should be granted to him. Can you imagine? I sought prosecution sanction of the 66th court Andheri, the magistrate. My sanction was denied. By whom? By the registrar of the High Court and the law secretary of the state of Maharashtra. And no reasons are given. Like I said, 300 crores defrauded by the public servants. The criminal manual says they are not protected by law if provident fund money is touched. The judicial officer passes the order. saying that they are protected under this act. I seek his prosecution and I get a letter saying, as per rules, prosecution sanction is denied. What rules? Which rules? What have you conducted? The Supreme Court says that any order passed has to be a reasoned order. Imagine I get a 2-line letter from the registrar of a high court. You mean to say the registrar doesn't know that a reasoned order has to be passed? Then is he fit to sit in that chair? Are these people fit to even sit in that chair? If they are the interpreters of the law and this is their interpretation, contrary to Supreme Court judgments, contrary to High Court judgments, they act and they want to be protected from prosecution. Because no lawyer, mind you, no lawyer will seek the prosecution of a judicial officer because it is his bread and butter. I concede that. I've got no issues with that. But is he being an honest lawyer? Is he doing justice to his vocation? That his client is being denied justice and he does not raise his voice in court because he's worried. He's worried that this judicial officer will be cussed, will be vengeful. He's worried. So I conceded to them. But can the judicial officers be vengeful and spiteful because we are telling you that you don't know the law? In fact, if you read the Anju Chaudhary judgment and the judgment before that, Anju Chaudhary versus State of Uttar Pradesh, it is a landmark judgment in which it is clearly said that if the judicial officer cannot differentiate between a 156(3) application and a 200 application, it is only because of lack of knowledge. That has been politely put by the Honorable Supreme Court because they did not want to say this is corruption. While the high courts, the other courts are critical of everybody as in every citizen, they are fraternal when it comes to protecting their own judicial officers. And I make this statement with full responsibility. I have documents. I am proud to say that during the COVID time, all the Air India flights that took off were illegal. The Bombay High Court held so, the Supreme Court also held so. I was the only person who sent a legal notice to the President of India to amend the Epidemic Act. Lawyers who are on this forum, correct me if I am wrong. The Epidemic Act 1860 was a 1-page, 4-paragraph act. There was no mention of aviation in that because in 1860 there were no aircrafts. I concede that. In 15 days, the amendment did come in. But then again, they look at how these public servants cheat the public. They say we have a right to inspect the aircraft, but where is the right for that aircraft to take off? If a human being is not allowed to go from one district to another district during the COVID, how is an aircraft being allowed to take off from one country to another country in violation of COVID norms? And no judge has raised this question. And I raised it, and an FIR is filed against me in the Marine Lines police station fraudulently. I battle every day against the judiciary. Every day is a battle for me with the judiciary. In fact, I had the 22nd court tell me, you have an issue, go and challenge my order. And when you go before the judicial officer, say that this act is under the Industrial Disputes Act, this is under the Societies Act, they say, but criminal case is not made out because that act will take care of it. They forget there are 18 judgments, and the most important judgment is Institute of Chartered Accountants versus Vibal Kumar Surana, where the Honorable Supreme Court looked at 8 other acts and said the judge or the judicial officer is only to see whether cognizable offences defined under IPC are maintained or no. Once it is maintained, don't worry about the act. Tomorrow I'll be doing a program. I don't want to get into that, but I just had an order passed by the 22nd court saying no, this is a labor court matter, so you take it to the labor court. Whereas the Supreme Court Constitution bench has clearly said that if an employee is deprived of his salary and terms and conditions are not followed, it's a criminal offense. And this corrupt judicial officer of the 22nd court passes an order like that. This 22nd court magistrate and the 66th court magistrate agree that our services were terminated under a non-existent document, but he says no criminality is made out. If a document doesn't exist and somebody claims it exists, is it not forgery? Common sense. But then, as they say, common sense is not common. So, if anybody thinks that a judicial officer cannot be prosecuted, they are sadly mistaken. A judicial officer or a public servant is protected as long as he does his job within the four corners of the law. He goes outside that, he is a commoner. The protection is gone. If the judges and in the courts tell me ignorance of the law is no excuse, then does that same thing does not apply to a judicial officer? And the latest trend in judges and judicial officers, at least in the trial court, is that they have stopped dictating their orders in open court because their corruption will be exposed. The 22nd court just passed an order a week back saying the matter is dismissed. Can you imagine the order is uploaded after 8 days or 9 days? So once he decides to dismiss my case, now a story is being fabricated as to how the case will be dismissed. And this was done exactly because that is how I caught the magistrate in the 66th court. When he told me I've dismissed, I said, tell, show me. And when he showed me the order, and I said, sir, this section, this act does not apply. You read your criminal manual, read the application I made in the morning. He says, no, I didn't read the application. Anyway, I've dismissed it now. What can I do? And then because I told him that, sir, you're helping the accused, he mentions that in the order. And he says, I will not listen to your case anymore. So escaping. So it is a fallacy if anybody thinks that a judicial officer cannot be prosecuted. I'm having the same problem in the Borivali courts as well. And there is an unwritten rule in all the magistrates court that if Mr. K.V.J. appears, delay the matter. Delay the matter. So it is a public servant, a judicial officer can be prosecuted. There is no bar in that. And I hope that after listening to me today, at least two people will get up to fight the injustice in this system. And I thank PLEA for giving me this platform to tell you how we can take on the corruption in the judiciary. This is the last bastion. The legislature has let us down badly, and we know how. The executive, we need not talk, the executive has lost its spine. Is the judiciary also losing its spine? The executive was known as the steel frame, STEEL. Today, the executive has become a STEAL, chori karo frame. Every posting that is sought has monetary value attached to it. And the poor people are assaulted if they go to the MADA office to complain. If anybody has an open mind, visit the MADA office after 7 o'clock. It is the den of builders and MADA officers. They couldn't be bothered if the builder has not paid the ordinary citizen their rent for years together. They couldn't be bothered if the builder has sold off their properties to somebody else. They couldn't be bothered as long as their pockets are filled. I would have given out names, not that I'm scared. Like I said, I just got an order for an FIR, 46 FIRs to be filed against the vice president of MADA. And you think anything has happened to the government? The government, no. Because, like I said, the legislature and the executive have become one. The judiciary, which was a sacred cow, is no more sacred now. They are also leaning towards the legislature. And it is a very sad state of affairs. And that was one of the reasons I agreed when Malavika asked me to speak on public servants and how they should be prosecuted. I've given all the judgments. Actually, I have a PowerPoint because if I do the PowerPoint, it will take me at least 4 hours. It's a 90-page PowerPoint. It's got all the judgments. It's got all the sections. It starts from 154.1 to 197 and onwards. I'll be giving it to Malavika and she will distribute it to you. So I think I've spoken long enough. If anybody is bored, I apologize for it. But then the angst of a common man as to how the public servants are taking citizens for a ride cannot be kept under wraps, or it just cannot happen. And like I said, I once again thanks Malavika and PLEA for letting me come onto this platform and discuss it. Over to you, Malavika.
Thank you so much, sir, for enlightening us and really. So, participants, let's put the queries. Use the raise hand function. We'll unmute you. But
Sir, very good evening.
Evening, sir.
Sir, it was a wonderful lecture, and I am very much inspired. Might be I'm fighting a little bit, a very few percentage the fighting which you have carried on. And I would like to join you on 25th of January because I'm based at Nasik, sir. My name is Advocate Yogesh Patil Gurjar.
Okay, fine, sir.
So,
there will be a pamphlet put out by that group. There's another platform that wants us to come to Nasik. We are coming there.
and the second thing is, sir, um, I just wanted to know that how many threats you you might be getting not many threats, no, because you're directly fighting with the judges and the public prosecutor, public officers.
Patil Saab, if you're born, you have to die.
Yeah, that is what that is only one inhibition in my mind to join in this mission with you.
Yes.
Otherwise, I'm a
Thank you.
fighter and like to join with you, sir. That's all.
Good, good. Just help out the poor people in Nasik. I'll be happy with you. I get a lot of calls from Nasik
I'll
because
do
this
that.
is
I'll
my
do that.
second session in Nasik.
I'll do that, sir. That is my responsibility. I'll do that. No issue.
Thank you. Thank
Thank
you
you so
so
much,
much.
sir.
thank you, Yogesh, sir. Next participant.
So good evening. Thank you very much for that very insightful session. I managed to make 4 pages of notes. I used the RTI Act to get information on various complaints, issues, civic issues. That's what I currently do as a citizen and also attend Mohalla committee meetings from Pune, sir. So my question now, even we face this problem where when there were many violations of the Tree Act, Urban Tree Protection Preservation Act. One of our citizen groups demand was that prosecution should happen against the tree authority head, which is the municipal commissioner. They did not, the judiciary did not, the civil court of Shivaji Nagar refused, saying that they are protected. So get
No,
permission.
they're not. So they're not protected, sir. So tell them it's a myth. I will send you the judgments also.
How do I go about it, sir? I need something to read. I'll do my research. I'll do my reading.
Like I said, I give you my PowerPoint, and that it says what are the judgments. There are a lot of latest judgments also that have come up, which I didn't discuss in detail. But we will be preparing a PowerPoint, adding. I already have a 90-page PowerPoint. We'll be adding the latest judgments, and there is no protection. There's a latest judgment also that's coming called Om Prakash, right? Om Prakash Yadav. It says
Okay,
to
sir.
file an FIR, there is no need of sanction. Sir,
Om
I
Prakash.
just give out my telephone number, so you can write it down. Give me a call. I'll assist you in whatever manner I can.
Thank you so much, sir.
Welcome, sir.
So, you also do Facebook Live every Sunday, right?
Yes, I do a program called From the Mock-up to the Lockup, and it's got and it goes on the name of Nalla Rao, Nallarao.
Yeah. So, sir, what's the name of your Facebook handle, your account name?
Nallarao.
Okay. So, participants, you all can also connect with sir every Sunday on Facebook. Sir, at what time?
11 o'clock. Normally it's between 11 and 11:30 I go live. Depends
Okay.
on what it is. But I'm live by 11:30. I'm live. I do one or two incidents, which I mean now I'll be discussing the 22nd court's order tomorrow morning, as to
Okay.
how its erroneous.
Hello, am I audible,
Hello.
sir?
Yes, sir. Yes, please tell me.
Sir, recently we faced a very peculiar case in which one of our officers was terminated on the charges of corruption of about 2 crore rupees. So
Okay.
his termination was upheld by the Honorable High Court. But when and we conducted inquiry for 1 year, SIT was found by the government, and then criminal charges up to life imprisonment are also going on. In
Okay,
spite of
criminal.
and yes, and all these things were brought up before the Honorable Supreme Court. But what happened was, Supreme Court division bench gave a judgment that no inquiry was held. When their inquiry was conducted, charge sheet was submitted, inquiry report was submitted to the delinquent officer, his representation was considered, and after that decision was taken to terminate. And now, and we also came to know that there was a bribe of 1 crore rupees given. And now, can we make an inquiry against the Supreme Court just to the CBI, because that man is now going
No,
to be
sir.
the
Why?
next.
If the order says that no inquiry was conducted,
Yes, but
and you
actually
have
inquiry was
conducted
done.
and you have conducted the inquiry,
Yes.
then file a 195 340 application in that court. No, sir. There is perjury that has taken place. No.
Sir, we filed the review, but the review was also dismissed, and then we had to pay 33 lakh
Cost.
rupees years. And immediately after that, we reinstated and we suspended him again within 1 hour. That's what
No,
state government
sir,
had to
that
do.
is what I'm saying. Sir, file a 195 340 application saying that the accused has filed a false affidavit in court. So then the court will now be forced to look into whether an inquiry was conducted or no. Huh?
No, sir, the petitioner never said that inquiry was not completed. He himself had enclosed the complete inquiry report in his petition, and in spite of that, the
Yes.
Supreme Court bench said that no inquiry whatsoever was conducted. Even a
Yes,
show cause.
my suggestion is to seek his prosecution sanction, sir. You have my mobile number. You contact me. I'll give you the judgments and I'll give you the format under which you can seek his prosecution sanction.
Sir, actually, matter is not related to criminal prosecution, but it is related to civil termination. That is dismissal from service, and even
Correct,
that
sir.
was
So,
and
sir,
terminated with full benefit by the Supreme Court.
you should have immediately filed a criminal case on him, no?
Sir, we have filed criminal case. 2 FIRs have been filed. 39 orders have been passed. He was arrested. He has been framing of charges. The matter is going on in the trial court, and
Okay.
all these facts were put up before the Supreme Court. And SIT, Special Investigation Team, has been constituted by the state government. In spite of that, the Supreme Court states that no inquiry whatsoever was conducted, not even a show cause notice was given, and that man is now going to be the next Chief Justice of India. So what CBI can do against such a judge, Supreme
No,
Court
sir,
judge?
that is the right to the president, sir. I'll tell you one thing, sir. I use the social media very much.
Hmm.
So you seek prosecution sanction of the judge from the President of India. Okay. And that letter, after you put all the details, circulate it on the social media. There is no bar on that.
But how can impeachment be done, sir?
Sir, impeachment, then you are asking for the moon, sir. Impeachment will never happen in India.
Yes, because impeachment is impractical in
Yes,
India.
but Veeraswamy's judgment of the Constitution bench also says that criminal offences are not protected, no?
Yes.
Seek prosecution sanction to file a criminal case on him, because that order that is passed is illegal. So
Yes, sir.
it is a public servant framing a false record, no? So to section 217, 218 of the IPC, you can use that against him.
But how we can use against the Supreme Court judge, which says that no inquiry
Sir,
whatsoever
he's a
was
judge.
conducted?
He's a judge as long as he does his job. The moment he gets into criminality, he's no more a judge. He's a criminal. So you have my number, so you can contact me. We will
Yes, I will
talk to
contact
you.
you because if he becomes Chief Justice, then that becomes a problem for entire India.
Yeah, sir. That is the problem, no, sir. Everybody, we keep quiet, and today they are sitting on our heads, no?
Yes, sir. Yes, sir.
Yeah. You have my number. You can call me up later.
Yes. I have noted your number. Thank you, sir.
Welcome.
Namaste, sir.
Namaste.
I am Girish from Bangalore.
Yes, sir.
Sir, I am asking a little bit out of the box, very fundamental question.
Yes.
Because I give it a lot of rapt attention, and really it's amazing. And more than amazing, it's so motivating that each one of us keep thinking that we are up against a hill. But when we hear our brother and sisters in this fraternity, we feel that most of us are fighting against the same, in the same allies. But
Yes.
if suppose with all your heredity and wisdom and experience of so many decades, if the clock is turned back and you carry back this particular experience, what would be your approach? Because right now your approach has been very earnest, walking through the front door, following all the procedures, fighting with a lot of stamina, and that's that. But is there any approach that you think One is just now you mentioned about social media making society aware. Apart from,
Correct.
do you think there is any other approach which you would have undertaken based on your experience if the watch was turned back against
No,
this?
sir, if the watch was turned back and if the judiciary was good, I wouldn't be sitting here and giving you this lecture, no, sir.
Absolutely, that's right. Yes, yes.
So, if each one of us does our job, sir, I'm not saying I'm perfect, but when I'm got documented evidence and I'm showing it to you, and still as a judge you overlook all that, then it disheartens you. And let
Very
me
much.
tell you, those people who've done it have become directors in Air India, have looted crores of rupees from Air India. There are captains who have got promotions to GM level and higher level. Can you imagine a pilot GM robbing 303 crores salary from Air India? Air India says you robbed, and still the magistrate is saying, I have to think whether there are cognizable offences. What do you do with such kind of a magistrate? Rather
Very
than I mince no words in court also, sir. I maintain the decorum of the court, but I mince no words.
It's hitting the truth on the head itself. Really
I,
appalling, sir.
do I have a choice? Karo ya maro.
Absolutely. Yeah.
So it's
Yes,
okay, sir.
sir. We'll continue our crusade, sir. I think thanks to PLEA, such a wonderful forum they have created. And in fact, the fallout of that is that like-minded people like all of us, like our brothers from Nasik and Pune, and myself, a lot of us should come together in this common foray of seeking justice and continuing our endeavor.
Yeah, in my seminars, I teach how you can fight your own battles.
Great, sir. I'll be a regular attendant there, sir. Thank
And
you.
they're all pro bono, sir. I don't charge anything.
Very noble, sir. Very noble of you. Thank you, sir.
Thank you.
Hello, good evening, sir.
Good evening, sir.
Aju here, sir.
Hi, how are you?
Fine, thank you, sir. Thank you so much, sir. Sir,
Tell me,
sir,
sir.
the old same case, sir. I brought it to the SDO level. I requested you for your guidance. My house and the land in Ratnagiri.
Okay.
Sir, in fact, after the sale deed was done, before the papers were name was changed on the Satbara, I filed a complaint to the Tehsildar from collector to the Talati and the other peoples that we have the documentation. I have possession since my grandfather, like 60, 70 years, and I have all the documentation of assessment tax and everything, sir. That before you hear me out, please don't change the name on the Satbara. But they did not listen to it, sir, and they went ahead. And then I filed a case, as you advised, with the subdivisional officer. And last week, I had a hearing there, but the opposite party, they did not turn up. Sir, now as this, your suggestion, as your guidance today, that I want to file this criminal case against the Talati and
Sir,
the
if you visit us, then we'll prepare us. We'll look at the documents here and we'll see what best we can do for you. Because discussing that here will take a lot of time and
no,
getting.
just I want to know, sir, that you said that without getting the sanction from
Sanction.
prosecution,
Yeah,
can I go ahead with it, sir?
of course you can. It is a myth that they are protected by 197.
So that application, if I can get it, sir.
Yeah, we'll send it to you.
Okay.
I'll give it.
Thank you so much, sir. Thank you so much. Thank you so much.
Hello, sir. Sir, before 2 to 3 years, I was brutally assaulted by police. I was smoking cigarette on the road. I was taken to the police station where two different officers told me two different fine. One told me 400 rupees, another told me 1200 rupees. Chaos took place, argument took place, and they assaulted me brutally. Later, I was taken to the medical where I told the doctor my lips are bleeding, my ribs are swollen. He just said, okay, there was no, he noted nothing. Then I was brought back to the police station and I was left by the police. Then I came back to home and told my father. My father at that time also used to work in a police department. The person who assaulted me was a colleague of my father, with whom my father worked at least 3 to 4 years in an externment department. Later, I made a complaint. Departmental inquiry was initiated. It was directed by the DCP to the inquiry officer to complete the inquiry within the 7 days. But inquiry report was submitted after 1.5 months. During this period, that officer tried to convince my father twice, and when they realized that this matter is not going to end, they made a false report against me and submitted to DCP. When I met the DCP, he said we will stop their one increment, and later I found that through RTI that only strict warning was given to them, and they were left. Then I approached the Human Rights Commission. There I fought my case. That time I was not able to afford advocate, so lawyer. I fought my case on my own. For that case was there for 1.5 years. So cause notice was issued to them. Someone was issued to them. They did not appear, but another officers appeared. 1 lakh rupees compensation was given to me.
Okay.
Yeah, police department took that amount from their salary and given it to me. Then he challenged that order on the basis of natural justice in the High Court. What now I'm trying to ask you, sir, the reason behind giving all this brief, what now the order is executed, nothing is left, but still the matter is going on.
No, the
So,
order is executed because the order was given to the commissioner of police, no?
ha ha
And they deducted the salary, no?
ha.
He's invoking his fundamental right that I was not heard by the Human Rights Commission. So then that was he should have been made aware. Did you serve notice on him?
The notice was served by the commission to them.
To whom, sir? To this police officer also?
Yes, yes, sir.
Then where is the principle of natural justice being violated? He'll not win the case. Carry on. Show the court the records. Let him show the courts the records, no? So you can show that it was served on him. So what principles have been violated?
Okay, sir. Thank you so much, sir.
Welcome.
Sir, the only thing, sorry, sir, sorry to interrupt, sir.
Yeah.
The only thing, when they filed writ application, they made party to Human Rights Commission, Director General of Police Maharashtra, and third party is me. At the
Yeah.
time of court admitted that it is maintainable. So
Ah.
now I hired one lawyer who is my teacher also.
Mhm.
So he said that nothing is going to happen in this matter, but still, expert opinion is always matter for me. That's why the reason I'm asking you this.
Sir, see, the case being maintainable, whether the court wants to hear whether his fundamental rights were violated, is maintainable. But that doesn't mean that the case is in his favor. It only means
Oh,
that the court is willing to listen to him and you together, maybe.
okay, okay,
No, so
okay.
just keep an open mind and take it from there. So then you don't have a problem.
Sure, sir. Thank you so much, sir. Thank you so much.
Welcome. Welcome.
So, uh, again, thank you very much. And my question is twofold, sir. During
Yes.
first appeal hearings under RTI Act, before first
Uh-huh.
appellate authorities, I
Uh-huh.
have two experiences. So, I mean, I have many experiences, but two grievances. One is where a situation where the first appellate authority twists my words, writes
Mm.
whatever he wants in his first appeal order, and
Mm.
goes against me. I have no the relief I know is I should go and file a second appeal.
Mm.
But second appeal now also takes 2 to 3 years. So one where they're twisting my words, where they're writing whatever they want in that order,
Mm.
and I only have the second appeal with me. Is there any way where we can do something with them
Yeah,
at
but
the
have you
level of
given
the
anything in writing to the second appellate authority?
okay? And the second experience is where they intentionally don't write things in the first appeal order. They hide
No,
these
sir,
facts.
you not answered my earlier question.
Uh-huh.
I said, have you given anything in writing to the second appellate authority?
Yes, sir. I have. I have mentioned this.
So if anything contrary to that is written by the officer, then it is public servant framing a false document, no, to help the accused. File a criminal case on them. It's maintainable.
Okay, sir. So where will this have to be filed?
Sir, you have to start with the police station.
Okay, all right. So section false evidence.
I think it's 217 or 218 of the IPC. The BNS, I'll have to just refer to it. I'll get back to you.
Got it, sir.
If you have my
This
number,
is
you can
after
call
the
me
second
later.
appeal.
I'll tell you what it is.
Got it, sir. So this is after the second appeal. I mean, first
Yeah.
appeal happens at the ministry level.
Yeah. So where you can once At any stage when a false report is filed and you feel it is false and contrary to what you have given in writing, he has fabricated a report, so you can take action against him, sir.
But during these appeal hearings, sir,
So
we also have discussions beyond what is in writing.
No, that's all right, sir. Leave it at that. Sir, I don't want to get into those grid. I'm simply saying you you have asked me whether a criminal case is maintainable. I've said yes, it's maintainable under these sections. So
Got
just
it, sir. Thank you
carry
very
on
much.
with that and just do it that way. Okay?
Okay, sir. Got it. Thank you so much.
Welcome.
Sorry, sir. I'm the same person who asks about you that REIT application. Prathamesh, sir.
Yeah.
So you asked me whether the notice was served to those officer. I had
Yeah.
filed complaint in the Human Rights Commission. Commission summoned them to the
No,
DCP as well as to officers there.
Was that particular officer also summoned?
Yes, sir. Through DCP.
Then where is the principle of natural justice being violated? He was given an opportunity, he was heard, and the commission took a decision. And that's exactly what even the Human Rights Commission will tell the court. That we served notice, he filed his reply, we have come to a decision.
Even after summon, he did not appear. Only few officers appeared from DCP office. Nothing else.
Then the best thing when you write now, sir, talk to your lawyer, ask him to file a 195 340 application for filing a false affidavit in court. If notice was served on him and he didn't attend, then how can he claim that principles of natural justice were violated?
Okay, sir. Thank you. Thank you so much, sir.
If you don't appear, you waived off your right, no?
Yes, sir. Even show cause notice was also issued to them. They gave a written reply to the show cause notice.
After waiving off your right, you cannot go to a higher forum and say like, my rights are violated, no?
Oh, yes, sir.
So that's a false application. File a perjury application. I don't know whether your lawyer will do it, but you can file a false application.
Okay, sir. Thank you. Thank you, sir.
Welcome.
Hello.
Yes, Mr. Matthews.
Yeah. Very good evening. My heartfelt appreciation to you for all the big fight that you had been with the redevelopment fight, and today the stand with many people who have got justice. Many people have got justice. No, with your help, I am one of the beneficiary. I am the first beneficiary, to be very frank. Now, yesterday also, sir, I had been to the Udupi court.
Yeah, I saw your message.
Yeah. Yesterday, I was not happy with the order that was passed by the magistrate, because basically the document that is filed with the court was a fraudulent document, and from the day one in the trial court, we were harping on the document which is false. The general power of attorney has not been produced at any given point of time, but still the order is given against us. So yesterday the magistrate was very clear and did not give an opportunity to my advocate to open his mouth. He said, you pay 2 lakh rupees and take the key on the same day. No 2 months of no 2 months for vacating the flat. So I also did not say anything, and the next date was given on 29th. But there are a lot many things behind it. Like, no, if we abide by the order also, we are at the loser side, because the opponent has to pay the rental or the electricity bill that has to be bared by him. A lot of things are there, but the document basically is a fraud document. How to go about filing a case against the magistrate who has not looked into the document that has been submitted, or the arguments or the witnesses been produced? Not happy with the way the court is working everywhere.
Joseph sir, to be very honest, we should be discussing this across the table at home. So you're welcome home anytime, and we'll sit and discuss this. Okay, because what happens is, we expect a lot of things. Sometimes our expectations are not 100% met, so we are upset. So we'll have a look at it. I looked at your message. I'll also advise you when you come home. ठीक है?
Sure, sir. Sure, sir. Sure. I'm very happy. Thank you for all the support rendered to the redevelopment part.
Yeah,
To
thank you.
everybody
You're
who has
welcome.
not. Thank you very much once again.
Hello, Vikrant here. I had a High Court case for pollution from crematorium. So it was a sensitive issue during COVID. So what I saw that for COVID cases, it got some rapid hearing dates, like within 20 days for 3-4 hearings. And later on, the municipal corporation, who was the respondent, I was told that they paid the court to delay the hearing, and then for 6 months or 8 months, the court didn't list any date. So is that a reality, or I just got that as a
Sir,
information?
bribing to get your case on board and bribing to stop your case from coming on board, both are the truth. It's a reality.
And it happens only with High Court, or also happens
No, it
with
happens with
national
every
hearing
court. So
tribunal?
I just told you, na, like
Acha.
you go to the magistrate's court, like his clerk is dictating the time. नहीं साहब ना या दिवशी वेळ नाही त्या दिवशी या दिवशी घेणार.
Acha.
You bribe her, you'll get an earlier date. You don't bribe her, you will get a later date. It's a standard procedure in every court.
But then
There's
it's
not-
in lakhs or more than lakhs?
Sir, I wouldn't know because I haven't
Okay.
paid any. And I don't encourage it. So I wouldn't be able to
Yeah, got
answer
it,
that
got it.
question, sir. But it is a reality.
Okay, sir. So thank you so much for accepting my invitation. And thank you so much for sharing your expertise and also sharing your extraordinary experiences with us. It was a really enlightening webinar. Can't thank you enough. Thank you, sir.
And I should thank you for giving me the opportunity, and you're most welcome, Alvika. Anytime you can call me up, even we'll always be there for you also. Don't worry.
Sure, sir. Thank you.
Thank you. Thank you very much.